Emmons is here on behalf of Mr. Reed, and I'll see if Miss Jolene Fowler. Jolene Fowler, are you on the line today?
Yes, Your Honor.
Okay, welcome, Ms. Fowler. We're on today for a presentation of an order from a hearing back on April 18th. It looks like Ms. Cotto forwarded a hard copy of that proposed order to the court, which I have. I'll ask if Ms. Fowler, if you have a copy of that proposed order.
I have a copy of an order regarding service.
So the document I'm looking at, the top right corner states order on hearing for April 18th of 2023. Do you have that document?
Is that the document for order regarding communication and service?
Let me just double check. So let me just pull up my file here. Looking, Mr. Emmons, is the documents, which I have one proposed order that was forwarded to me. Are there others?
This is the only order I have, Your Honor.
Okay. So
is the order not regarding communication and service? Is it something different?
it relates to that. Yeah, definitely the content of it. Yes.
Okay, because I'm getting extremely confused because they keep attaching these affirmations of counsel, which look like really long declarations to me. And they've been doing this my entire case. And then
so let me just, maybe this will help, Ms. Fowler. I'm just going to hold the order that I'm looking at up to the screen so you can see it, to see if you have that. That's the document I'm looking at. Can you see it?
Yes, I can see that. I believe
that's what I'm looking for.
If I do have it, because what I picked up from the courthouse was a order regarding service and communication.
Yeah, and this one touches on that. Yeah. So are your documents just right where you're seated and you're just looking through them now?
I have some documents in another area, so I'm looking at them now.
Ms. Fowler, were you able to find that document?
Yes, Your Honor, I was, and it does say order on hearing for April 18th.
Yes.
And it requests service be provided by United States Postal Service or private processor.
Right, and so our purpose today is to review this written order to see if it comports with what was ordered back on April 18th, 2023. So my question to you, Ms. Fowler, is do you have any objections to any of these provisions? Meaning, did Ms. Cotto get it wrong, or is this what the court ordered on that date?
What I remember from the hearing on April 18th was that we did agree for service to be by process server or United States Postal Service. And I have no objection to that. But what's confusing to me are these affirmations of counsel that are like a really long declaration. And they're scary to me because she requests me to not have counsel, then requests fees. And
so gratefully, we're not talking about those things today. Gratefully, we don't have to worry about any of that today. So so I have that order. If there's no objections, it looks accurate to me. So I'm in a position to sign off on it. Do you have any concerns with that, Ms. Fowler?
I don't have any concerns about serving Ms. Cotto through United States Postal Service or process server, but what I do have concerns with is her seeking me out, clear out in Long Beach, and demanding jurisdiction in an area where she knows she doesn't have any jurisdiction over me. I'm getting really concerned about this. She's evicted me from a property I had no possession, saying I have declarations saying where she says there needs to be a record. This woman has demeaned me, literally violated my human rights and civil rights. It's pretty obvious that they are tracking me and trying to keep me here. I'm being imprisoned to this area and I don't live in Cowlitz County. I'm pretty much being told I can't move with my daughter. This man hasn't seen his child in about 5 years.
Okay. Ms. Fowler, thank you for your participation today. I've signed off on that order, and that'll conclude today's matter.
Your Honor, there's also a motion to compel on. Did you see that on your docket? It should be number 3. It's the one.
Just a friendly reminder to you're not actively involved in the case, if you could mute your phone, please.
And I believe it was sent over from a previous day, Your Honor.
Yeah, I apologize. I took notes on that.
And I'll tell you our position. It might make it easier. We received no response served on us to it. I checked Odyssey this morning and it appears Ms. Fowler filed some papers. They weren't done under the penalty of perjury. It doesn't appear, nor does it state the location of where she signed them, which is required. So the court couldn't consider those, I don't believe, today anyway. So what I would ask is the court set that over for a week when Ms. Cotto can argue that. She is much more familiar with this case than I am.
So Ms. Fowler, maybe those are some of the things that you were addressing earlier. So there's a request for the Ms. Cotto's motion to compel discovery that be set over 1 week to the 16th of May. So Ms. Fowler, are you still on the line?
Yes, Your Honor, I am. And
Are you comfortable if we just set it over 1 week to address that issue?
I'm comfortable setting it over 1 or 2 weeks because I haven't been served that. The only thing that I have are these affirmations of counsel, which look like declarations to me. And then this order that we just spoke on.
Okay.
Those are the only things I have. I don't have a motion to compel. I have these affidavits of counsel, which look like declarations. So I don't.
So yeah, it looks like you filed a
Odyssey.
document. It looks like you filed a document in response to that motion to compel, where you asked the court to deny the motion to compel. So it looks like that you've responded to it. So Mr. Ammons just raised a concern that you might want to just address. He indicated that your response to the motion and other things that you filed as far as declarations, there's couple key things that we're missing. That there's a requirement that any declarations be written under the penalty of perjury, a statement indicating as such, and also indication of where the document was signed. So those are the things. Those are two of the things we'll be looking at when we address hearing. And I was just checking to see if there was any objections that had been filed. I didn't see any, and I just wanted to touch base with Mr. Reed if you had any objections to any of these proposed orders.
I just have one issue, Your Honor. We didn't have any opportunity to file. We didn't receive the drafts until yesterday. But the only issue is on section 4 of the parenting plan, the decision making. I don't believe there was a ruling in the hearing about decision making. Ms. Green has assigned those to all decision making to Ms. Giske. And we would object to that. We would think that there should be joint decision making. There isn't a reason otherwise.
Okay. Right, Ms. Green.
Yes, Your Honor. So first, I do want to state that there is a declaration that we filed yesterday showing that Mr. Reed and Ms. Fellows both were served via email with the proposed orders on Friday when I left for vacation, and I have those emails. But nevertheless, I believe that hopefully you have the signed orders that Ms. Fellows signed yesterday, and I presented to the court late yesterday afternoon. So they're agreed as to Ms. Fellows and I had not received any response from Mr. Reed until now. This is the first response. Regarding the decision-making, the court ruled that you were adopting the guardian ad litem's recommendations. In her report, this was her recommendation, there be limited decision-making, and the reasons were based on those that are included in section B, which was the neglect finding in 3B, the ability of the parents to cooperate, and the distance, because my client is in Beaverton and Mr. Giske is in Woodland. So court, if you recall, transitioned custody over to mother in this matter. And so given the level of conflict and the recommendations from the guardian ad litem, this matches what her recommendations were.
Okay, I'm just refamiliarizing myself with the minutes from the hearings. In reviewing the clerk's minutes, obviously it's not a verbatim transcript. It just gives kind of an overview of things. I don't see any specific mention of decision making in that summary. There's a couple of ways to approach this. Probably not going to resolve it today. One issue would be one way to do it was to review the video. I could do that. I could look at it and see what was said or not said, and then to set it over a week or so we can finalize the orders.
Your Honor, I can reference you back to page 15. The last line of the guardian ad litem recommendations was decision making should be limited to the mother due to 3B findings, as well as the distance and lack of cooperation between the parents, which is what I adopted. And my understanding from your ruling was that you were adopting all the guardian ad litem's recommendations. And so that's why I adopted that language. I don't believe I can check back on my notes if it was specifically discussed either, but I just want to reference you to what was included and why.
And of course,
that's fine.
Our argument, Your Honor, would be that the 191 restriction already has a limitation within the parenting plan in that the complaint was that the house was messy. And I don't believe that having a messy house should interfere with for major decisions related to health and schooling. There's already a restriction elsewhere within the parenting plan. I think that the requirement is fulfilled otherwise.
Okay, and let me just touch base with the parties. Besides that, the decision-making issue, no other objections to the proposed orders?
We have no other objection, Your Honor. Thank you.
Okay. All right. So, yes.
Sorry, I
Ms.
just have a quick question. So I don't have an objection, but the court did advise that the house needs to be clean prior to visitation for the child. The court did find that neglect was based on the cleanliness of the house. My client is just concerned on how we monitor or how she knows whether or not the house is clean prior to the visits. She is asking for either pictures be taken prior to the exchange or something to confirm prior to the exchanges because they needed a halfway point to make sure that he's compliant. So that is my only concern at this point. We have included that in the order, but there's no enforcement mechanism for my client at this point to know whether or not that's been done.
Okay. Well, that's probably something we can talk about next week. So if there's a specific motion, probably need to file that motion because I don't think we addressed it. But if the parties have some suggestions you want to put down in writing, we can address it next week along with the decision-making. Devin Wood and Ms. Bliss present representing Tammy Wood. And we're on today for presentation. And let me grab the proposed. So there were some proposed orders filed and there was just a limited objections to those proposed orders. So I'll just touch base with Ms. Bliss as to your objections, and then we'll hear from Ms. Baldwin in response, please.
Thank you, Your Honor. And most of I think there was 3 objections, 2 of which weren't expressly written in Your Honor's lengthy ruling. So I was just hoping to address it for today. And that was the issue of a money judgment as contained in my client's trial aid and testimony at the time of trial. Mr. Wood was to have paid $2,500 in spousal support from the period of October until the trial, excuse me. And you heard testimony from both parties that none of those spousal maintenance payments were made. So my client was asking at the time of trial for a money judgment, essentially encapsulating those overdue payments that weren't made during that time period. My apologies. My request for the court today was to issue a money judgment, essentially from the time of October to current, which has a arrears of $19,178.59. If the court is going to enter a judgment as of the date of the trial, obviously that was contained in my trial aid, and that was a $13,178.59 judgment.
Yeah, let me just ask for a little clarity there. So with the order requiring maintenance to be paid at the amount of $2,500 per month from October to February, because the trial was held in early February, I believe, 5 times 2,500 is 12,500. And then do you get to the 13,178 by virtue of interest?
Correct.
Okay.
So that was the interest at the date of the trial. I can recalculate interest if Your Honor is going to make it effective as of the May 1 date, but I just essentially included the interest from October to the date of trial.
Okay. All right. Let's having heard that, let me just hear Ms. Baldwin's response to that.
So first, there's no written order that this is based from. This is based from an oral order, but it's never been reduced to writing, which is problematic. Second, this wasn't addressed at trial. So again, not an issue that counsel brought before you at trial, nor requested that you make a decision at trial. If the court is now going to issue a decision, the court then has to reflect temporaries are just that. They're temporary and they can be modified by the trial judge. At trial, you set my client's net income at $3,500 per month. If spousal support is $2,500 and you add an additional amount for child support, that essentially gets to a place that would exceed statutory cap. So it's just simply not a viable order as far as the total amount of the transfer payment and what you ordered at trial as my client's net income. So if we're going to make this decision, you have to make it sort of knowingly and not as a sort of, by the way, after the fact judgment added in.
Ms. Bliss.
Your Honor, frankly, counsel's argument that this is essentially the first time this is being addressed is factually inaccurate. As Your Honor likely recalls, A, in my trial aid, B, in my proposed orders submitted at the time of trial, and there was testimony from my client regarding this order, regarding the fact that the parties expedited this to trial post that hearing in lieu of going back and forth fighting over that proposed order. We simply saved it to address it at trial. That was the testimony of my client. That was my position and argument at the time of trial. So this isn't the first time this is being addressed. The order is the order, whether it was reduced to a physical order or an oral order. Your Honor is well aware of that order, and that has been addressed at length at this point. So it is proper that that is included in there. To simply not include it in a final order is essentially waiving all of Mr. Wood's obligation that he failed to pay throughout the pendency of this action.
And rebuttal, if you allow it.
Sure.
It's not a waiver. So the court at trial, counsel never specifically asked in opening or closing for you to make a judgment regarding this amount. And it was only addressed sort of tangentially within the trial testimony. If counsel's asking you to make an order now, you're certainly free to do so. But to do so, you have to do so knowingly. And I think you have to make an active order, meaning that you have to think about that and then decide what you want to do versus just make a judgment. And again, when the judgment, the monthly amount is essentially the same as the court has ordered my client's net income, court has to take that into consideration, along with the fact that you ordered my client to pay 75% of the community debt. So again, in a situation where the request, your order that you've already entered is 75% of the community debt and spousal support, and my client, the court establishing my client's income at more than his actual income, there has to be some amount of thought towards this arrearage and what we do with this arrearage on a final order.
Thanks. Well, I was just looking back at Judge Hahn's October 4th ruling, where she indicated that the court orders, at least the minutes indicate, court orders $2,500 per month total payment from petitioner Mr. Wood to Ms. Wood, respondent. Will need orders, court signs parenting plan, reserve on attorney fees. So that's a verbal order that probably still needs to be reduced to writing. It is still a valid court order, just needs to be put into writing. So that makes it more tangible, gives it more contours, more effect. So then the next step is that at trial, it sounds like that issue was addressed, maybe not at great length, but there was some testimony according to counsel that was addressed. So the court, when fashioning a decision at trial, takes all the information that's presented at the trial and comes up with a decision that is hopefully equitable and fair. A past order that has not been fulfilled or satisfied generally remains at the time of trial. So I'm inclined to award the amounts requested. However, I think we need to have that order reduced to writing from back October 4th, the October 4th hearing. So there's a basis, a firm basis on which to require that payment. I do want to give some consideration to the trial and the court's letter decision in conjunction with the request for the $13,178 or the $12,500 being included in that particular decision. Let me think about it a week, and then can we come back next week and think about it and talk about it a little bit more?
Certainly.
That works.
In this Bliss, you'll be drafting an order for the October 4th decision related to maintenance.
Yes, Your Honor. Frankly, I think it's already been prepared. I think there was an issue with income calculations at the time of the last hearing, which is kind of why we just sideswiped it and went to trial, but I'll confirm and I'll converse with Ms. Baldwin.
Okay, I'm just jotting down a quick note to myself. Okay, thank you for your patience. We'll come back next week. We'll address that issue, and I'll thought about it a little bit, and you all will too, and we'll come to some decision next week.
Okay.
Great.
Did Your Honor want to address my only remaining?
Yeah, let's do that.
Or-
Let's do that.
Okay, so I misspoke. It's my second objection. That's the same as the first. So my third objection is as it relates to the child support order, section 19B, the tax exemption. I'm just simply asking the court to include language that petitioner's ability to claim the child for purpose of the tax exemption is contingent upon him being current in both his child support obligation and a spousal support obligation. Obviously, we're before the court spending lengthy time on his failure to provide for spousal support throughout this case. My concern is once the court enters these orders, that behavior is going to continue. He's going to reap the benefit of this child support obligation while minimally supporting his former wife at that point and this child. So we are asking the language be included that he be required to pay or be required to be current in both his child support and spousal support obligations in order to receive that credit.
Thank you, Ms. Baldwin.
Because the benefit here is tied solely to the child, and the federal benefit is tied solely to the child, it should be based solely on the payment of child support. You didn't order it either way. We just traditionally adopt the language of current and child support. Although the child is 17, I believe she ages out in 6 months or less.
And my letter decision, I don't believe addressed tax exemption, did it, Ms. Bliss?
It did, Your Honor.
It did, okay.
I think
It did pay them. I believe it was my client claims this year, Mr. Wood claims next year, and then obviously I think at that point she turns 18.
So Ms. Wood could claim for 2022 and Mr. Wood 2023.
Correct.
Yes.
All right. So I'm comfortable with Mr. Wood being able to claim the tax exemption for 2023 if he's current in his child support. That's traditionally what we have done, and that's traditionally where the real tax benefit comes from, is because there's a child and that bestows a credit or the like, which usually results in several thousands of dollars of either credit or refund or what have you.
Does your honor wish to sign some of the orders now that aren't objected to, or do you want to just wait on all of them? I don't have a preference on it.
I'd like to sign some things today.
Okay. I don't think there's any issue, and counsel, you can correct me if I'm wrong, with the parenting plan, then with that ruling, the order of child support, and the findings of fact. I think it would just be the decree.
The decree. Mm-hmm.
So I think your honor can sign everything but the decree, and then we'll just address the decree next week.
Okay. And then I have electronic copies of those documents that were filed in Odyssey. And let me just double check, did the party submit that via email? I'm just not sure if I saw those.
If you don't have copies with wet ink on them, I can send the ones that we've discussed to Ms. Bliss this morning, first signature with her, and I'll sign, and then we'll send them over this afternoon.
Okay, great. Some wet ink would be appreciated. I'm comfortable with the tax exemption being conditioned upon the payment of child support. I'm going to hold off on tying it or condition it to payment of maintenance.
Okay.
And we'll talk about the remaining 12,500 maintenance, whether that becomes. And Ms. Dow, you are, just so I have my parties sorted out. Tell me who.
I represent Mrs. Gilliam.
Okay, you're representing Ms. Gilliam. Great. And I see that Ms. Gilliam is on the line today. Good morning. And I'll ask if Randall Gilliam is on the line today. Randall Gilliam, if you're here, please unmute and state your name. Randall Gilliam. Okay, I'm not seeing or hearing a response from Mr. Gilliam. That may not come as a surprise. It looks like he's been uninvolved for several different hearings.
Yes, Your Honor.
We're on today for Ms. Gilliam's motion to enforce the divorce decree or order. Looks like notice of today's hearing was sent to Mr. Gilliam. In particular, I'm looking at clerk's paper number 55 that was sent to his address on, and there was also a note for today's docket for May 2nd, but today's the 9th, 25th was noted, and the 18th was noted. So was there a notation, Ms. Dow, for giving him notice of today's hearing?
Your Honor, we did give him notice for today's hearing. We had him served once by the sheriff's office. The next time the sheriff went out, I believe they said they were unable to contact him, but we also served by mail, which this is a subsequent pleading in this matter. So we also served him by mail. He's had every reasonable attempt to tell him he needs to deal with this.
Yeah, I do see that. In particular, that's the April 4th certificate of mailing.
Yes.
Where he was served by mail the motion to enforce the decree, the proposed order, the declaration of Ms. Gilliam, and a notice of hearing and amended notice of hearing. So that's the question, is that notice and the amended notice of hearing. So I'm looking at the amended notice of hearing. It gives a date of May 2nd. And I'm not seeing a notice for May 9th.
Okay, that is odd because there should have been one that went out to him for May 9th.
Okay.
Your Honor, this has gone on for so long, we can certainly serve him again. Strongly doubt he's going to appear. He has not responded to anything that we've sent to him.
Well, let me just double check in the court record.
Yeah, please do. I was under the impression that we had sent out a notice for May 9th.
So on May 2nd, there was a hearing held. Commissioner Baldwin was on the bench. Ms. Dow was present. There was a discussion regarding notice of appearance. The court addressed Ms. Dow regarding conflict and continuance. Court ordered that Ms. Blonda be removed from the case. Court set the matter over to May 9th. Said the cases that were the parties that were present were Ms. Gilliam and Ms. Dow, and Randall Gilliam was not present on that date.
He has continued to ignore us.
Right. So I think their service is appropriate. He was served for the hearing on May 2nd. He was not present on May 2nd. That's the date that was set to hear the motion. Unfortunately, couldn't be heard on that date, but he was given notice. He chose not to be present or was not present on that date and was set over to today. So I'll grant your motion.
All right, thank you, Your Honor. In the motion, and I will check into that. I thought we had sent him additional notice that it had been continued to the 9th. We're trying to do everything possible to get him to participate. In the motion that we submitted, we presented a couple of options in order to get this dealt with. But given that Mr. Gilliam is still refusing to participate, he is ignoring everything that comes to the house. We are asking that the court actually order that Ms. Gilliam take possession of the home for the purposes of getting it cleaned up and listed for sale. The home was awarded to Mr. Gilliam in the divorce, but the divorce required him to make an equalization payment to her within 90 days. That is long past. He is letting the property fall into disrepair, both inside and out. And Ms. Gilliam would like to get it sold. She has her Social Security and she's living with her children, and that's it. That's all she's gotten out of this marriage. And the only way that she is going to receive anything is if the house is sold. And he hasn't cooperated with anything else. He hasn't done any of the things that the court asked him to do or ordered him to do. And so we are asking that the court choose the option that allows her to actually take possession, get it listed for sale, and get this dealt with.
So you're referring to your proposed order on page 2 of the order, section 1A, that says respondent must vacate the marital home located on PH 10 and remove personal property no later than 15 days from the date of the order. And the listing needs to be confirmed within 40 days or 45 days of entry of the orders, and then striking the alternative of listing the home within 7 days of entry of the order.
Yes, Your Honor.
Okay.
Yes, Your Honor. It's very clear he's not going to cooperate in listing it for sale or in refinancing, which he could have done last year when he was supposed to. So we are asking that the court order that Ms. Gilliam take possession and list it for sale, and that he be removed, or he remove himself. Hopefully we won't have to remove him.
Okay. All right. So I see that proposed order that you submitted on March 24th.
Yes, Your Honor.
So just so we're on the same page, when I look at page 2 of that order, I'm going to be striking 1B, which is the alternative.
Yes.
2 will be included, 3 will be included, 4 will be included, 5 will be included.
Yes.
Okay, so B6 is removed, strike that. And then 7 would remain.
Your Honor, pardon me for interrupting, but I believe section B should simply be removed. The entire thing was predicated upon him actually applying to refinance the mortgage. And we don't believe he's going to do it.
Okay, and so then that would be striking paragraphs 6, 7, 8, and 9, but keeping 10, correct?
Yes, keeping 10 and keeping 11.
Honestly, I can print it out and then I'll make those strikes and leave those portions that we talked about. And I'll get that filed.
All right, thank you, Your Honor.
We're on today for presentation. Ms. Bliss is present, Ms. Baldwin is present. I thought I saw Mr. French earlier. I'm not sure if he's still on the line.
He is still present, Your Honor.
Okay.
Yes, Your Honor.
Okay, I can hear Mr. French and Sarah French. It looks like she's also on the line. Ms. French, can you hear me?
Yes, I can hear you.
Okay, great. Thanks all for being present today. So we're on today for presentation. I've reviewed the proposed orders along with the objections to the same, and also a memorandum of law that Ms. Baldwin filed. So we'll just jump right in, and I've got some sticky notes and we'll just work our way through these. So if we could start first with the child support order that Ms. Baldwin drafted, and objections have been filed by Ms. Bliss. I'm looking at page 3 of 10 on paragraph 11, the start date. I'm going to keep April 1st as opposed to May, so I'll keep that there. And then if we move to page 5 of the child support order, paragraph 19, A is in alpha. There it's alternating. It's proposed that Ms. French have the right to claim tax exemption in even and Mr. French in odd. So I'll hear from each party. Ms. Bliss, why don't you go first since you're objecting to it?
Thank you, Your Honor. And it is my client's position that since Ms. French had just claimed the child in this most recent tax year, that naturally he would claim next year, which would be an even numbered tax year. So we are just continuing essentially the status quo at this point. Ms. Baldwin's prepared order essentially gives Ms. French 2 years of tax exemptions back to back. So we're just essentially requesting the court to adopt status quo. It was your honor's ruling to alternate. So we're just proposing that my client have even numbered years consistent with years past.
Thank you. Ms. Baldwin?
If my client claimed it's because he was not paid up, if you look at the prior temporary order, I alternated maintaining the last order. Essentially, I maintained if they're even an odd status from the temporary order. The temporary order was also alternating and had Mr. French has the right to claim the child in odd number tax years.
Okay. And then in practice, Ms. Bliss, you indicated that odd years went to mom most recently in 2021.
Correct.
Okay.
For tax year 2021. So she just claimed the child.
Have the 2022 taxes been filed yet? Do you know?
I don't believe so.
I don't know either way. Based on the order, I see what the date of the entry is. The prior temporary child support order was entered in 2021, and that's what they've been based off of. It was October of 2021.
Okay. Ms. French, do you have an input?
Yes, I did just claim Granger this year, and he did claim Granger last year. Okay. So for 2022, I claimed Granger, and then 2021, he claimed Granger.
Okay, I'm a little bit confused. So in 2021, who claimed Granger?
Bryce did.
Okay.
And I just want to make sure we're clear, 2021 being the tax year or the filing year? Because I think that's where we're getting confused.
The file, sorry.
The filing.
So for 2020, there we go.
Yes,
Okay.
yes.
Okay, so then it sounds like then Ms. French claimed for tax year 2021 and 2023. Now I've circled myself into a tizzy. So this is what I think happened. I think Ms. French filed in 2020 for 2021.
So whenever I just filed my taxes here,
Yeah.
Granger. So in January, whenever I filed my taxes for the previous year, I claimed Granger.
Okay, so
in January 2022, she claimed for Granger in 2021.
I think, let me just double check, Ms. French, see if I got this. In January of this year, you filed your taxes, correct?
Yes.
So that would be for tax year 2022.
Yes.
And then that's when you claimed Granger.
Yes.
Okay.
And that's consistent with the prior temporary order. So the order as proposed maintains that same structure.
I think we were just getting confused at that point, Your Honor. So I withdraw that objection.
No, that's great. I'm glad we worked through that. So I'll leave that as proposed. Then jumping to page 7 of the child support order, it reads, long distance travel costs include unaccompanied minor fees and the cost for a single required trusted adult to travel with child via airfare. And that's where Ms. Baldwin's memorandum comes into play, I believe. So I'll hear from you, Ms. Bliss, and then from Ms. Baldwin, please.
Thank you, Your Honor. And I did receive Ms. Baldwin's memorandum. I did have the opportunity to review the case law. I do agree at this point that the case law that she's provided is consistent with her order in that the long distance fees should include a trusted adult traveler. I would just note that that wasn't Your Honor's ruling. So it's still my objection that the language contained in the order is inconsistent with Your Honor's ruling, but I'll defer to the court.
Thanks. I probably need to follow what the law says that the Court of Appeals has stated is the law. So I'll do that. I'll follow what's required. So that means that the proportional share of of airfare applies both to the child and to the accompanying adult traveler. So I think that the proposed language just remains. No changes to that. So
I think with that, the child support order is good to sign.
I'll sign the child support order now. The parenting plan, which has just a few stickies on it. So I'm looking at the parenting plan proposed on page 2. Go ahead.
Oh, so because many of these are on the same topic of the amount of notice that has to be given, I'd like to address that issue first. Because there's I think 5 or 6 that are basically on that same topic. So if you look at your letter ruling at page 5, the last line of that reads, these flights shall be booked at least 45 days prior to the flight's departure date. Each party shall provide the flight information for booked flights to the other parent within 24 hours. So I essentially just adopted the 45 days across the board because it's logically inconsistent otherwise. And so that's why council sort of like, well, it was supposed to be 30 days and 45, but if they have to give notice of the flight within 45 days, you have to give notice of the travel within 45 days.
Yeah, I guess it's booked 45 days prior, and then within 44 days, you're giving notice because there's the 24-hour requirement.
Yes.
Okay. Ms. Bliss.
And Your Honor, I was just simply adopting the 30 days as there's several other provisions looking primarily at page 3. Your Honor lists a 30-day requirement for essentially when he comes to New Mexico, he's to provide 30 days, mothers to provide 30 days notice of her selected weekend. So for purposes of consistency, I simply just adopted that 30 days across the board. But I do acknowledge that Your Honor did order 45 days in that specific section. My concern obviously is these parties do tend to have a lot of conflict. And if there is any sort of inconsistency, I just am anticipating a lot of issues moving forward of, oh, I thought it was 30 days. Oh, I thought it was 45 days. But I'll defer to the court on that ruling.
And I'll just reference the order does still maintain the 30 days where appropriate. So where he's visiting in New Mexico, the order does say 30 days. When it talks about my client reserving her weekend on page 4 of the order, it does say 30 days. It's essentially when the child's going to fly, it's 45 days across the board if the child's flying.
Right. Well, I apologize for the somewhat internal inconsistency of the 45 and 30s. I think parenting plans are great documents, but it's nice to have the shorthand. And I think the shorthand is really important in when sometimes when there's higher conflict or maybe more disagreement with things. So I'm going to opt for the 30 days across the board.
So the financial realities is more logical.
Okay, I wasn't aware that 30 was kind of a magical number. Ms. Bliss?
I frankly don't have a position on that. I think that there's abilities to find cheap flights regardless. It was my client's proposal to do 30 days, and I think he's bearing the brunt of the travel costs. So he's prepared to move forward with the 30 days if that's what Your Honor rules.
Okay. Well, I don't know much about airfare costs, that kind of price break points and the like. I do know that having a consistent time frame is helpful. On the one hand, 45 days is a little more lead time and prep time and may make it maybe harder or more difficult with work. I'm not sure. But if we have it at So let's do this. The consistency is important. I'm going to go with the representation that there's it's financially advantageous for the parties when you book it out further. There's nothing stopping them from doing that, but kind of as a rule, I guess, 45. I'm comfortable making that across the board, just the 45-day time period, where it talks about counseling and recommendations, medication management. And then I think it was the last little bit of the language that was objected to. So Ms. Bliss?
Are we skipping over the 3A inclusion? Before we get too far, I just wanted to make sure that we are intentionally not addressing.
No, I apologize. I didn't stick it. I didn't put a sticky note there. So go ahead and express your objection.
Thank you, Your Honor, and that's contained in my objections and in Your Honor's ruling. You indicated that upon completion of his domestic violence treatment that the limitation will be removed. I'm simply asking a little asterisk next to it, indicating as such, upon successful completion of domestic violence treatment plan recommended by Ms. Lovely, the court will allow removal of this limitation. It was my understanding that that was the ruling of the court, so we're asking for that to be included.
Thanks. Ms. Baldwin?
So as referenced in my memo, there really is no authority for the court to remove a factual finding. The factual finding is the 3A finding. The court's order as written is to remove a limitation, but not the finding. I think removing a finding would be unprecedented and certainly problematic when we try to rewrite what happened at trial and the findings that the court clearly made at trial. So the finding that the court made at 3A remains. He could remove the limitations that are down below at 3 or down at 4. As he completes those things, then you could enter a new parenting plan that doesn't list them because they've been completed. But to remove the factual finding just simply does not comport with law. There's no authority to do that.
In Your Honor's brief rebuttal.
Please.
Thank you. Given Your Honor's ruling and the recommendations of the guardian ad litem that didn't limit my client's time, didn't limit joint decision making, a 3A finding is simply unwarranted. I understand that Your Honor wants or has required him, to undergo or continue to complete the domestic violence evaluation. But considering once that is completed, Your Honor's removing that limitation and then there's no other limitations contained throughout the parenting plan, I simply think a 3A finding is inappropriate and unnecessary at that time. Your Honor will obviously correct me if I'm wrong, but I don't believe it was the intention of the court, given Your Honor's ruling, that 3A language would remain after his completion.
Okay, thank you. Thank you both. So the 3A limitation says there's a history of domestic violence, and domestic violence is presented in very, very broad terms. I mean, that can mean a whole host of things. So I think there is a history of domestic violence. I think this is a domestic violence on the far end of the scale? I don't. I think it's more on this side of the scale, meaning less severe, if you want to put it in a severity scale. So I'm fine keeping the history portion in there, because I think that's an accurate statement, and I'm okay in removing the limitation that comes thereby once the completion of the treatment is verified.
Okay.
And I don't know if that's properly or adequately presented within the proposed order.
I'm wondering if it might be easier if we redo, because we've already made some, I don't want to discredit your Honor's whiteouting, but I think it might be cleaner depending on what your Honor decides to do with the remainder of my objections, it might be cleaner just to enter a new order. I mean, of course, I'd love to enter all of the orders today, but I'm wondering if it might be better moving forward if we have a new order.
I like clean orders. I like clean orders. So let's do that. So if that language could be inserted, that it's okay to, it's once completed with the treatment, then it's perfectly well and good to remove any limitations associated with that finding, paragraph 1. So Ms. Bliss?
Oh, go ahead.
I would just note that wasn't in your Honor's ruling. I understand that that's typical for these, and I don't have any strong opinion as to why it shouldn't happen. I would just note that it wasn't in your Honor's ruling. Thanks,
Ms. Baldwin.
Absent the compliance reports, there's no ability for my client to know what's happening. And they issue them regularly. They were part of the trial on what they issue. It's essentially a single sheet of compliance on a monthly basis.
I'll keep it in. Paragraph 3 of that same section, there's a request to remove the last sentence. If he's released from care, he shall notify the mother and provide proof that care is no longer recommended by the treating provider.
And again, your Honor, I don't believe that was in your ruling. I don't know why it's necessary, but I'll defer to the court.
Thanks.
Essentially the same problem.
I'm going to keep it here. It reads, if the parent does not follow treatment requirements above, then all contact and visits shall be suspended until further of the court. Mr. Friend shall provide compliance reports prior to any in-person visit with the child. Ms. Bliss?
And I think this just sets up for in the event that there is a lapse in treatment or counseling, this is going to cause a substantial gap in contact between my client and the child. As your Honor is aware, it takes at least 3 weeks to get into court if there is any sort of issue for any motion. Granted, there is options for a motions order shortening time. However, at that point, maybe he needs to hire a new attorney, what have you. There's substantial circumstances that will prevent contact between the child and my client. There was nothing provided or ordered by the court that the limitation on domestic violence, and the court neglected to find a finding for his mental health. I don't think it's necessary to suspend visits. Obviously, that matter can be reviewed by the court if there's a lapse in treatment, but I don't believe that suspending all contact and all visitation is in this child's best interest or was the intention of the court.
Thank you. Ms. Baldwin?
So the standard language on the pattern form is sort of has and if they don't comply, X happens. There needs to be some carrot and some stick. The court didn't rule sort of either way on what those were. So this is sort of my default. If the court wants to say, instead of suspend, say, can be brought before the court on a short time basis, that would be reasonable.
Okay. I'm going to strike that language altogether and just leave it out. On page 4, line 15 there, that's related to special holidays, Thanksgiving, spring break, Christmas, counting those visits as one of the father's visits for the month, no more than 2 Washington visits in any calendar month. Ms. Bliss?
And again, this wasn't ordered by the court. I would just note too, in typical and standard parenting plans, holiday time, summertime are in addition to the normal residential schedule. This essentially replaces one of his normal residential schedule times with that holiday time, which in essence removes an additional visit that could potentially happen that month. So I would ask the court to adopt our language by removing that altogether.
Thank you. Ms. Baldwin?
So this is part of our original proposed plan. Again, there's very real practicalities when you're flying a child across the country to a location that is not a Delta hub. And so if we're flying the child twice in a month, that's already wildly expensive. By the time you're flying the child 3 times in a month, it's not doable. It becomes an impossibility, just financially for really both of these parties. So I think this is just a practicality. Again, this is part of our original proposed. We'll just rest on your Honor's order.
Thanks.
And I would just note that your Honor adopted my client's proposed holiday schedule. So while I agree that this wasn't included in Ms. Baldwin's proposal, the court didn't adopt that. And your Honor said, I might be mincing words here, but your Honor essentially said that there's going to be costs associated. That's unfortunately the costs that occur when parents move outside of states. So I think all of the parties are well aware that this is going to cost more. It shouldn't be a basis to limit my client's time with this child.
Okay, I'm going to remove that section, just strike all of it. I think, money is definitely an issue, and that child's time with father is important, and if they're able to spend more time together, then that's great, and that should be encouraged. So we'll strike that. Related to the precise time as opposed to after school on Thursday. Ms. Bliss?
And it was my recollection, and I was trying to find your ruling real quick. It was my recollection that Your Honor actually included that 3 o'clock timeline. You did. So on page 3 of your ruling, you indicate specifically petitioner's visits will occur every 3rd weekend of each month from Thursday at 3 p.m. to Sunday at 6 p.m. I acknowledge that Ms. Baldwin changed the time to 6:30, which we appreciate given the flight schedule, but Your Honor did specifically rule 3 p.m. So I'm asking that be reflected in the order.
Thanks.
And if Your Honor recalls, we agreed to this language. So one of the very first things we did at trial was we agreed to the language that's in my proposed order. So again, we've agreed that the child is essentially going to miss 1 day of school. We didn't agree that the child would miss 2 days of school. Child doesn't live in El Paso. Child was about an hour outside of El Paso. El Paso is just the airport. So again, the agreement that we reached and put on the record was this language right here that's in the proposed order. I'm asking you to adopt it because it was agreed.
Ms. Bliss, any recollection? Agreed.
I don't have a recollection of that, but I'll defer to the court in the record. I would just note again that Your Honor made that specific ruling in your finding.
So Ms. Bliss, when you indicate that it's, was it in the written order or the written letter decision?
It was, Your Honor. It's reflected on page 3 in the school age section. It's the very first line of your school age section. I'm not denying that very well could have been an agreement. I just frankly don't remember. Obviously, this trial was several months ago at this point. I have no issue with Your Honor checking the record. I just saw in your written ruling you did indicate 3 p.m. So I was asking to adopt that language.
And I don't disagree that that's what you wrote in your written ruling. It's just not what we agreed to. I think Your Honor just sort of ruled on it, not remembering that there was an agreement.
And the agreement was presented at trial?
Yes, as part of our opening, where we said these things are agreed, and we agreed on the school schedule that this part of the school schedule was agreed.
And the difference in between the two, after school versus 3 p.m., if it's 3 p.m., then the concern expressed is that the child would have to leave school early to get to the airport. So they'd have to leave at noon or something.
Yes, so then the child's missing essentially an entire day and then a portion of the next day, when that doesn't even make sense given the flights that are available. And again, it was agreed because everybody sort of in this case understands some of the practicalities on flying this trial that distance.
Well, I've always been a proponent of parties making agreements, so I'll leave the after school language. Let's see. There, the objection is the removal of the first sentence, which reads, the child's flights to Washington shall be scheduled such that the child has time to finish the school day and arrive at the airport at least 90 minutes prior to the flight time. Ms. Bliss.
And Your Honor, I think that was largely contingent upon your ruling on the prior objection, but I would also note too, I think it's agreed between all of the parties that there's essentially one flight that leaves and it's later in the evening. I don't know, frankly, when the child is released from school, when the, obviously it was presented that it's about an hour drive from the home to the airport. My concern is having that language in there that requires the child to be there 90 minutes prior to the flight time. But I understand that that's, TSA recommendations or what have you. So I'll defer to the court on that, given your previous ruling on my last objection.
I think I'll leave that one in.
Okay.
Then let's jump over to page 5, the language of petitioner may exercise additional visitation with the child in New Mexico. So basically between the second and the third word, exercise additional visitation. Ms. Bliss.
Correct. And that was Your Honor's ruling. So I just like the order to reflect that.
Thanks. Ms. Baldwin.
And so you're looking at page 5, line 4.
Yes. So where it reads petitioner may, then Ms. Bliss is requesting to insert the phrase exercise additional visitation with.
Sure, no objection.
Okay, we'll include those 4 words in between may and visit. So I'll read petitioner may exercise additional visitation with the child. The request is to remove the sentence when the father exercises visitation for Thanksgiving, spring break, and Christmas. That shall count as the father's visits for the month, no more than 1 visit. So I'm striking.
Sorry.
Yeah, I'm
I would just note that Your Honor did adopt that language in my previous request under the school age schedule. So that's the same objection.
Right.
Just
So
in a different section.
I'm striking that paragraph.
Okay, thank you.
It says remove the language. This is in the table. Remove the language beginning when the child begins school.
So the way I read this, Your Honor, is all of these holidays do not begin until this child begins school, which means he won't have Thanksgiving holidays. He won't have winter holidays. So I would like the removal of that language, as I'm sure it wasn't the intention of the court that he's not to celebrate Christmas or the like until this child begins school.
So this was their proposed order that they proposed at trial and you adopted. So now they're saying, well, gee, we proposed this, but now we don't want this. You really can't do that now. So the court said, I'm adopting whole hog, their proposed language. That's what's there. Okay. So I took it directly from counsel's own pleading.
Yeah, I think notwithstanding the adoption of the hog, we're going to cut up the hog a little bit and maybe slice the bacon a different way here. So I think it's important that the spring break between ages 2 and 5 or 2 and 6, the father have time with the child. Same thing for Thanksgiving. Same thing with winter break. So I think in even numbered years, if you look at spring break, it would read in even numbered years, striking beginning when the child begins school, end strike. From the day school is released, might need to be massaged a little bit according to the school calendar in New Mexico, in the school district where the child lives.
Have you heard of that? Why does it matter? Why does spring break matter when the child isn't in school? It wouldn't have any impact on the parties.
No, I mean, it just matters to foster a time and a place and maybe consistency of schedule through the child's life. Not to say that this is going to be a forever parenting plan, but it might be. And if the child gets into the groove of having time during spring break, I think that's a positive. That's kind of my thought process.
I mean, it says if the child's preschool aged and doesn't cognitively probably have that presence of time, this can result in, so it's a period of time where it can result in multiple visits in a month. Again, when the parties are financially strapped. It's challenging because this wasn't argued because the court ordered their language. So at trial, this wasn't an issue presented based on how they presented their work.
Yeah. Yeah, and I think my same reasoning applies, notwithstanding some of the shortcomings that Ms. Baldwin has pointed out, is that we'll strike that language related to the beginning of school and just put it in place. And like I said, the language may need to be massaged a bit to indicate, the adopting or utilizing a school schedule where the child, in the school district where the child lives. And related to air transportation, there's a request to change verbiage related to on line 12. The language reads, currently when the child can fly as an unaccompanied minor, the petitioner shall book both legs of travel and pay associated unaccompanied minor fees. The request is to change the language to add the petitioner shall book both legs of the travel, and each party shall pay the proportionate share for the child's flight cost and any associated unaccompanied minor fees for visits to Washington. Ms. Bliss?
I was just going to look at that. I wondered if that had any indication on the previous issue that you've already addressed.
Right.
Line 12.
The court did order that when the child can fly unaccompanied, that father was to book both legs. It makes sense that he then pay those fees. But then if you look at the order of child support that we entered, then mother's going to pay her proportional share. It's just he's the party that's booking them.
I think it's encompassed in the child support order, so I think we can. No, okay, sorry, my apologies. So the concern I have with the language as presented, it essentially is suggesting that petitioner is booking both legs of the travel and he's paying all of the unaccompanied minor fees. I just wanted language included to show that that's shared. My apologies.
Yeah, I think there, because as the language as proposed, it reads the petitioner shall pay associated unaccompanied minor fees, where I think the intent was that the parties would share that cost. So I'm fine with keeping the petitioner shall book both legs of the travel, and then each party shall pay the proportionate share for the child's flight cost and the unaccompanied minor fees. So I'll adopt Ms. Bliss's language in section 12. In that same section, this is on
reimbursement.
Yeah, and
I argue it doesn't belong here.
Yeah, I'm just kind of curious about placement. So reimbursement, the language requested is reimbursement for the child's flight costs and associated unaccompanied minor fees for visits to Washington shall be paid to petitioner within 30 days.
And I suppose it could be included in the child support order in lieu of in the parenting plan, but it needs to be included somewhere. I figured that since we were addressing fees and costs within this section, that this would also be appropriate. But absent any sort of timeline, my concern is that there has been issues in the past with reimbursements coming later, not at all, inappropriately done. So I feel that a timeline needs to be included in order to ensure that both parties are footing the bill essentially with the cost of travel. Because at this point, my client's fronting all of the costs and hoping for reimbursement. If there's no requirements or a timeline for reimbursement, my client is concerned that he won't receive said reimbursement.
Sure. Thanks.
So first, not pled, not argued, not ordered. Two, her client is not fronting all of the costs. Currently, each party is booking a leg of travel. Three, if the court puts a 30-day time clock on it, the court has ordered up to 3 visits in a single month, even if the unlikely event that costs for the travel are less than $1,000. Let's assume they're $1,000. That's $3,000. My client's proportional share is going to be about $1,000 for a single month. That exceeds his child support, and it's close to half of what she makes in a month. My client might need more time to repay than 30 days. The idea that we're going to create a contempt trap with the poor parent doesn't make a lot of sense. And again, it wasn't ordered.
And I would just note, contrary to counsel's argument, my client is fronting the cost, and that's the provision we just looked at. Petitioner shall book both legs of travel. So my client is fronting both to and from travel, and there's no requirement for reimbursement. Obviously, the thought is she's going to reimburse her proportionate share, but without any sort of timeline, we're kind of in limbo, and then that creates an issue moving forward.
That's only true when the child can fly as an unaccompanied minor. Until then, each party is booking their own legs of travel.
So the proposed language, Ms. Bliss, as it reads now, says reimbursement for the child's flight costs, any associated accompanying minor fees shall be paid. Okay, so I just needed to insert my own comma there. So now I feel better. Reimbursement for the child's flight costs, comma. Related to that, any associated unaccompanied minor fees for visits to Washington shall be paid within 30 days. So I'm fine with a date, a timeline for reimbursement. I think that's important. I think that the potential for multiple visits in a single month, at least for the foreseeable future, is unlikely, in that both parties aren't earning tremendous amounts of money right now. They're early in their careers. That may come up later. So I'm fine with a 30-day time frame for repayment. Ms. Baldwin brings up a good point regarding each party right now, while the child has to be accompanied, have to book their leg of the trip. When the child becomes an unaccompanied minor, that's when this provision comes into play. So maybe that could be teased out a little bit more clearly in the language there. For any cost associated with an unaccompanied minor flight, then that's when the 30-day time reimbursement comes into play. So I'll include that with that bit of a massage of the language.
Okay.
And I appreciate the parties helping with that. Parenting plan. This is on page 11, section G. This is related to the kind of the default rule for phone calls or video visits, as requesting Monday, Wednesday, Friday, Sunday, as listed in the letter decision, versus Monday, Tuesday, Wednesday, Thursday. Ms. Bliss.
And that is my objection, Your Honor. Your Honor ruled Monday, Wednesday, Friday, Sunday. My understanding of Your Honor's ruling is to space them out. So there is an extended periods of time where child is not having phone calls with father. Father simply requests to add this schedule as opposed to the schedule proposed by mother, which would essentially have him going 4 or so days without any sort of contact with his child.
Thank you. Ms. Baldwin.
My client's only objection is she never has a weekend to herself. So this precludes, the proposed schedule precludes my client from ever having a weekend where she can travel without him essentially being on board on a video visit. He has weekends, she should have weekends that are their own undivided time.
Thanks. Well, there's certainly nothing preventing any party from going away for the weekend and the child being in the care of another and providing a video visit during that time frame. So we'll stick with the Monday, Wednesday, Friday, and Sunday time frame. Again, that's a base level. If the parties can do something different, they can. Okay, so that's the parenting plan. Then I think we talked about child support, tax year exemptions, and long distance travel costs in section 22B. Did we address that in the child support order?
We did.
Okay, great.
Yes.
Okay.
Your Honor, before we get away, real quick, I just wanted a point of clarification. Given Your Honor's ruling on the 45-day timeline, I don't imagine that Your Honor's intention is obviously starting now or whenever we enter the final parenting plan that my client's first visit isn't going to be for the next 45 days. So my request is just a point of clarification that he can book this first set of flights and then moving forward 45 days notice.
Not if they're not booked now. If they're booked now, that's one thing. If they're not booked now, then no, the order should apply.
Then therefore my client's going 45 days without seeing his child, and I don't think that's the order of the court.
But he was aware of it as of the court issuing the letter decision.
So, Ms. Bliss, to clarify on your request, so I'm going to be signing orders probably next week sometime related to the amendments that have been done here today. And in the orders that we just reviewed, the travel time, the booking time needs to be 45 days in advance. Does your client have a particular time that he's thinking of visiting?
Well, I mean, considering Your Honor's ruling allowing him 2 visits per month, he's attempting to start exercising those. So my concern is if he does attempt to start exercising those, he's not going to be able to do so for a month and a half. So my request would be just this first round of this next month's visits, assuming that he's going to have a visit in June or May, that he be allowed to do so. And then moving forward, that 45-day notice is required.
And again,
I'm going to leave things as is, as far as the
Okay.
is.
we'll see if we can work out the direction you've given us. If we can, we'll strike this off next week.
Okay. And so
Do we want to address the findings in the final decree?
yeah, if we could. So on findings,
I didn't provide any objections, those seemed appropriate.
yeah, both parties signed off on that, so I'll sign off on the findings. It's 5/9/20. 20 years ago, people would say, what in the heck is approved by Zoom mean?
Hopefully, looking back at orders from many, many years past, we also ask that same question, but we'll see.
Right. Okay, so I've signed off on those. Then the worksheets. Any concerns with me signing off on the worksheet?
Nope.
Nope.
I think that's sufficient.
Great, I'll sign that, and then we'll look forward to, we'll set this over 1 week. If the parties get that parenting plan revised and agreed, we can strike things, otherwise we'll keep it on for next week. And we have Ms.
Okay,
very good.
Jocelyn representing Anna Rosencrantz.
Good morning, Your Honor.
Good morning. All right, so I see Ms. Jocelyn is here, and Ms. Petrie, you can hear me okay?
Yeah, I don't know why my video is not on.
Yeah, I can hear you just great, so that's fine. And then just recognizing that we have Ms. Anna Rosencrantz on the line, so we give welcome to all. Let me just pull up my notes, just a moment. I believe is on Ms. Rosencrantz' motion for temporary orders related to maintenance and the credit bill related to the care for the cats, and then no request for no change to insurance issues. So I'll hear from the moving party. Ms. Jocelyn, please.
Thank you, Your Honor. I'll be brief. I know your honor is quite diligent in reviewing the pleadings. This is my client's request for spousal support in the amount of $500. Mr. Waters has always been the primary breadwinner. My client would like to move on. She would like to attend school. She wants to either become a preschool teacher, an environmental activist. And in her declaration, we've laid out the plan in terms of the cost, how long it's going to take, how long it'll take her to find a job. During the marriage, the other side, I know they'll deny it, but he's the one who controlled all of the money and sort of doled out what he felt was necessary. So in a sense, she got half the money to pay all their bills. He got to keep the other half of the funds. I don't know where they are. That's going to be a trial issue or a judgment issue. In the financial declaration, we filled it out as a dual purpose. We listed it as proposed needs, but also listed what was current. So there's two different numbers. My client is only netting $11.99 a month versus Dane, who is netting $44.25.50. It should be noted he didn't provide any financial or any sealed source to back up his finances. It's pretty standard for the military. It's really easy to find out what they make. We went ahead in our financial sealed source, provided what his base was, what his BAH, what his BAS was. In the financial declaration, they did not account that BAH and BAS are non-taxable. It's only his salary that is taxable. So he nets $44.25. My client has no other sources in which to support herself. You know, she's going to require several years of school. Her parents, yes, are helping her, but her parents are not required to help her. If you look at his income or his financial declaration, he lists his expenses at $23.95.94. So when you take away his net from that, he has over $2,000 a month left over, in which he has the ability to pay her. Even with a $500 payment, he still would have $1,500 left over each month. Additionally, I know opposing party has stated he's leaving the military, but we have nothing. We have no orders, we have no letter, we have no discharge paperwork. Even if he was leaving the military, it's his absolute right at the end of his assignment. He knew, so he should have planned. He's now presenting that, oh, I'm leaving and therefore have no job. It's not like he is leaving the military and just found out yesterday. This is something that takes months in advance. Additionally, while he has paid some funds, the parties were together till April 2022. And so any funds he gave her were for the community. He paid her after their separation, May and June, $1,000, and then through January of this year, $600. According to the military, without a court order, if you look at the Marines manual, per the manual section 15004, at a minimum, he's required to support his spouse, and he has failed to do so since February. My client didn't call his command, which she could have, didn't try to get him in trouble. She's just simply asking for support. Just even according to the military, which I know has nothing to do with our standards, he would have been required to pay half his BAH, which is $581. My client has the need, he has the ability to pay, and so therefore we are asking the $500 a month in spousal. Additionally, my client's asking for the care credit bill to be paid by him. This care credit bill was incurred for the parties' 4 cats. Mr. Waters has the parties' 4 cats. He's taken them. My client has no idea where they were. He's the only one enjoying the benefit. He certainly can afford a $75 a month payment, even after paying spousal support. $2,500 in spousal leaves $1,500. A $75 payment leaves, $1,425 left over each month. Therefore, our client is requesting he pays $500 a month as in for spousal. He pays the care credit bill, and then an order that neither party is to change insurance.
And Ms. Joslin, did your client pay the cat bill, for lack of better terminology, for a period of time?
They were sharing it for a while. So he was giving her money even after. So when they had sort of physically separated, but not separated, he was giving her money and they were sharing it. And then she's continued to pay some of it.
Okay.
But she simply just doesn't have the funds any further to pay it.
Gotcha.
One of the things that council left out of this argument is the simple fact that this is a 2-year marriage. This is not a long-term marriage. This is a very young couple. They are in their 20s. Sorry, I'm still processing the information. The date of separation was over a year ago. So they've been separated for a year. They were married for 2. She wants spousal support. I get that. But my client cannot pay spousal support. He paid, council did represent that correctly, from April 2022 until July 2022. He paid $1,000 a month. And actually it was 3 months. So that's $3,000 is what he paid. Then from August through February of 2023, he paid $600 a month. So that's basically 11 months of support that she's already received on a 2-year marriage. There's no more. My client is separating. His enlistment was up. He did not renew it. Currently, he is in training and transition classes. He has to find a job. He's living with his mother. He is on terminable leave. He has his base salary. He no longer receives the housing allowance or the spousal allowance. I will also point out that there are no children in this case. So it's not like there's anything that's tying these two together. They've been separated for over a year. And during that year, he voluntarily supported her. What they did with finances during the marriage is irrelevant. But if we're going to go there, the reason he had to control the money was simply because she racked up credit card bills irresponsibly. And now she's in a position where she can't pay them. She didn't consult him when she took out those cards, and she just started incurring debt on her own. Of course, he had to take control. He had to stop the mayhem. He's already paid her over half the length of the marriage. And for a couple of kids, essentially, who need to get out on their own and start figuring out their long-term careers and education goals, that's what student loans, grants, scholarships are for. If her parents can't help her get through college, if, no one puts aside money for her when she was a child, that's on her then if she has these goals. Like I said, it's not like this was a 20-year marriage where she stayed home and was the housewife and the stay-at-home mom. No, there was none of that. This was 2 years in their 20s. Just as counsel indicated that her parents are no longer responsible to support her, neither is he. It's time for them to separate, move on. He will agree to pay half that care credit debt. He has no objection to paying for 50% of it. Whatever the balance was as of the date of separation, he will pay half of that. And he agrees that she's going to be entitled to half of whatever is in the TSP, the thrift savings plan. There's no dispute there. So I'd rather not have to go through this and keep coming to court to argue over things that these people don't have, and where the law doesn't support what she's asking for. So I would ask that the court order what we are in agreement to pay and deny the request for spousal support and attorney's fees.
Thank you. All right, and then Ms. Joslin, any brief rebuttal?
Very briefly, Your Honor. In regards to the care credit, the proposal isn't half. The proposal is he pay it all. He's the one who has funds. Additionally, he paid her 2 months of the 1,000. April, they were still together. And there's nothing that he's provided. He's provided no sealed source to show that he is not receiving BAH, was the base allowance for housing, and the BAS. The reason that he is getting that high of a BAH is because of my client. If he was not married, he would be getting less. So he is getting a benefit and getting more money because he is married. He has the ability to pay. There's nothing in his declaration or his financial declaration. He signed under oath saying he has $2,300 in expenses. That's $2,000 left over. There's nothing saying he has anything less. And regarding credit cards, I'm unsure what opposing counsel is discussing, as we only talked about the care credit. We're not talking about multiple credit cards she's asking. Therefore, my client's only asking for support for a short period of time. We're talking 7 more months. And then, of course, hopefully Ms. Petrie and I can finalize the rest of it. But my client simply doesn't have the means or ability in which to support herself, and he does.
Your Honor, at the end of June, he has 0 income.
Thanks.
There's nothing before the court that shows that.
It's in his declaration.
People could say anything in their declaration.
All right. Thanks both. All right. So as far as the issues here, so as far as the request for maintenance, Number one, the parties were married for a short period of time. They've been separated for maybe about as long as they were married, maybe a little bit less, but it's a short-term marriage, 2 years. There's no children involved. Mr. Waters does have the ability to pay, and it looks like he has paid. And there's lots of good reasons for that. Sounds like the military has applies some pressure there so that people will meet their obligations to a spouse. Sounds like the housing allowance is tied to that. And so it looks like there were some payments made through that. The way I look at this is that these parties are getting a start in life, with education and careers and the like. And Ms. Rosencrantz will be well positioned to start at, I think she mentioned Evergreen College in the fall and get started with her education. It's not uncommon. People starting with their education are poor as church mice, as they say. That's where you eat lots of top ramen and the like. Funds are certainly tight when a person's going through school. So I think here, given the situations and the facts that I've heard, I'm not going to require any maintenance to be paid. The credit card bill related to the care of the cats. Apparently there are 4 cats, and the 4 cats are in the possession of Mr. Waters. He'll be responsible for the payment of the full amount of the credit card bill related to the cats, since he's enjoying the full benefit of the cats and their presence. So then the half of the Roth IRA, it sounds like Mr. Waters indicated that Ms. Rosencrantz is entitled to that, and that she's also entitled to half of the military thrift savings plan. So based on those concessions, I'll award both of those in that.
Wait, which one? I'm sorry, which one?
Military thrift savings plan and the Roth IRA that belong to Mr. Waters.
Yes, Your Honor. You're not making any decisions on the TSP and Roth. I think that's something Ms. Petrie and I can certainly work out now that you've made your spousal.
Yeah, I mean, I think there was that concession made by Mr. Waters in his pleadings that he said that Ms. Rosencrantz is entitled to half of his Roth and half of his military thrift savings. Okay. So maybe I was premature in announcing that, but there was that concession. So there it is. And so if I need to roll that back, I'll roll it back. Just maybe there wasn't, maybe I was premature in that.
No, Your Honor, I appreciate it. I think you were just, so now I understand you're simply clarifying your ruling as to why.
Yeah. Yeah. So if that helps to move things forward, I haven't seen any documentation related to those accounts. Apparently they're present. There we have Ms. Winkles representing Ms. Sanderson, and we have Ms. Dow representing Mr. Larson, and Ms. Turnbull is present on the line with us today. And I'll see that. Let's see. And then Ms. Sanderson is on the line. Recognize her presence.
And Your Honor, Mr. Larson is present in my office.
Oh, okay. All right. All right, very good. So we're on today for, it looks like 2 different motions. One is the motion for voluntary recusal and or disqualification for cause, and then also the GAL reunification review. So those are the 2 items that I've prepped for. So I'll hear from Ms. Winkles on the first issue on the motion for voluntary recusal and or disqualification for cause.
And Your Honor, I'm actually considering asking for a continuance. I had surgery on my arm, and I've had 2 surgeries now this week. I'm really struggling, so I will attempt, but if I get very dizzy, I will have to ask for continuance if that's okay. I'm not sure if everybody would want a continuance now. It's just I thought I could do it, but I'm struggling a bit. Would
it be helpful if we took just a little break? You could just maybe lie down,
Well, I've got the other hearings after this, so that's okay. I'll do my best today.
Yeah, let us know if we need to take a brief recess. Okay. I'm happy to do
that. Concerning the recusal motion, and obviously we're not stating that Your Honor has any sort of bias or anything of that nature, but considering the sheer amount of litigation in this case, and considering my client did start a lawsuit in Oregon, and considering Mr. violating the court's orders, it is incredibly likely that this will be appealed either way. And when it goes to appeal, I don't do appeals personally, but when it goes to appeals, the record needs to be preserved. And there is an issue in this case. And that issue is that obviously my client sued a number of people, and Your Honor was one of them. Now, while everybody in this town obviously knows Your Honor, it does give the appearance of an issue. And it's that appearance that means that my client will essentially take from that if Your Honor and a different judge were to make different decisions, that there's a reason for that. And obviously Your Honor has more information on this than the other judges, but the fact is that for an appeal, which I'm sure that this is going to happen, it makes more sense for Your Honor to recuse himself so that is not part of the appeal. And the appeal is purely on essentially what they feel their rights are. This is even more so because this is a constitutional right to your children. And my client has been essentially barred from having any contact with her child for a very long time. And looking at the record and looking at the changes that were made, it becomes harder and harder to justify a complete cut from having any contact with her child, especially since she's had contact with her older children who have apparently turned out quite well. So, Your Honor, I'd ask that you obviously voluntarily recuse yourself in that it just give an appearance to folks like my client of some sort of issue. And like I said, although I don't plan on doing any of the appeal, I would rather, if they do the appeal, it would be on the issues of law rather than these collateral issues.
Thank you, Ms. Winkles. Ms. Dow, do you have any comment?
Your Honor, as she has done right along, the petitioner is making a number of statements with which we take issue here, but it is a fact that she did sue Your Honor in federal court, along with every other judge that was involved, the guardians ad litem, some of the other attorneys involved, including her own. The GAL report and all of the information that we've gathered that we will be presenting to the court ultimately pretty much supports our concerns, and that's not going to change regardless of which judicial officer hears the matter. So completely understand if Your Honor decides to recuse yourself. That seems to make sense.
Thanks. So I'm pretty familiar with judicial ethics in that I've served on the Superior Court Judges Association Ethics Committee for a number of years. I used to chair that committee. I'm on the Ethics Advisory Committee, which is a statewide committee that receives concerns that judges have, and then we write opinions on ethical concerns for judges. I'm also an alternate member on the Commission on Judicial Conduct, and I've been served on that for roughly 2 years. I'm not going to recuse myself. In 2017, when the pleadings came in today or related to the voluntary recusal, the first question I asked myself was I sued? Frankly, I did not remember. And then I Googled the cause number and I pulled it up and I thought, oh yeah, I did get sued. And then I remember a conversation from the attorney. She called me and said, we're going to file a motion to dismiss based on judicial immunity. I said, yeah, that kind of makes sense. Then the next time I thought about the case was when I got a call from the attorney and said, the case has been dismissed. I'll note that case, every person that touched that case got sued, including Justice Mary Fairhurst of the Washington State Supreme Court, Judge Warning, Commissioner Busby. Several attorneys were also sued, Alex Stivey, Tim South, and Amy Wade, who did not file any type of response to the lawsuit. The court, on its own volition, sua sponte, dismissed those claims against those attorneys. That tells you something. That tells you something. Also, the GALs, there was 3 of them. They were also sued. All of their cases were dismissed. So the fact that, number one, I forgot that I was even sued, the fact that I was only involved in the lawsuit for basically 2 phone calls from an attorney, there's not a basis there. Also, it gives concern that I agree with Ms. Winkle's contention that our justice system works because there is this standard of an appearance of impartiality. The system works because people think it works, right? However, parties can try to gain tactical advantage when that tactical advantage has already been spent. Certainly, an individual can file a notice of disqualification on a particular judge, but when a judge has made discretionary rulings, that's gone. And I don't think an objective, reasonable person, based on those facts and my recollection of the lawsuit back in 2017, would find that there is even an appearance of partiality. I think I've ruled on this case based on the facts that have been presented in the past, and take into account this is a case in which the court granted custody to one parent and the other parent absconded, was arrested for custodial interference, and was convicted of a crime. So I think that given those facts, those are pretty egregious and fairly glaring. That's been in long past in the history. But the fact of the matter is that a person that may have disobeyed that court's order and then suffered consequences by virtue of criminal prosecution may not feel comfortable with that judge hearing that case. I get it. I understand where she's coming from. I think another fact to consider is that the court has a lot of experience and historical exposure to this case, which I think is helpful in the long run when a court is making decisions related on the best interest of the child. So I understand where Ms. Sanderson is coming from, but I'm denying the motion. So we'll next move to the guardian ad litem, who Ms. Turnbull filed her report. I've reviewed that. I assume both parties have also reviewed that. And we'll hear from Ms. Turnbull of maybe any high points that you would like to address.
I think that the report is extensive and it's included in there.
All right, thank you. All right, so we'll hear from the petitioning party, Ms. Winkles.
Yes, Your Honor.
I mean, you're the respondent, but I mean, it's more her motion in that she's seeking reunification.
Yes, Your Honor. We're at a point now where reunification is not just necessary. I guess it's not just wanted, it's kind of necessary. It's a child that's gone a lot of time without seeing his mom, and for whatever reason, for whatever crime she may or may not have committed, and for what she did in the past, the fact is that we owe it just as much to that child to allow him to have a bond with his mother should he want it, as we do to my client. My client is not the same person she was 5 years ago. My client has gone through extensive counseling, behavioral therapy, medication, and the like. This is a woman who, frankly, had no job back then, had nothing for her, and she now has her own business. She makes enough money to pay me. She has a life that's stable. Her children both have talked to the guardian ad litem. They're adults now. They have their own lives. One of them has their own child. They report mom is great. Mom has done a lot to better herself. My client's willing to do whatever this court asks her to. Was she in that position back in 2017? No. Did she have potentially a breakdown, a behavioral or a mood disorder? Absolutely. She's not in that place anymore. She's done everything that's been asked for her. She's done everything. You'll see the case in Oregon, which gets referred to a lot in this. And I found it concerning that a lawyer from Oregon would be emailing the lawyer and up here in the JL up here when the cases don't have anything to do with each other. But I will say the transcripts of that case are very clear that my client did a heck of a job raising this little boy for 3 years, and my client was concerned with the child's medical care. That's it. Instead, the rest of the stuff that's in these reports and everything are allegations. That's what they are. They are allegations that have no medical backing up to them. My client has offered to do a polygraph. My client has offered to do, a parental risk assessment. My client will do anything just to have reunification counseling. We're not talking about having the child in a room with her with nothing. We're talking about lots of appointments leading up to her even having contact with the child, and then potentially some words and some phrases that are not allowed. And that's where we are, Your Honor, is that it's time for my client to be able to see her son. But more than that, it's time for the son to be able to know his mom actually cares about him. I'm not sure what else my client can do to pay for the sins of her past, but she's willing to do it if she's just given a chance to do it. She just asked for the 2 hours once a month. I think Ms. Turnbull talked about that. She's willing to start with that. She doesn't want to make the child upset. She's not asking for anything more than what Your Honor is willing to give her. She just wants the opportunity to form a bond with her child and to essentially prove to this court that she's not the same person. Thank you.
Thank you. Estelle?
Your Honor, the reports from the first of all, this is review of the guardian ad litem's report. That was the purpose for this hearing. We're asking that the GAL report be adopted in total. The reports from the child's counselor, Mackenzie Taylor, and this is a counselor that has had a relationship with this child for some time, and the guardian ad litem, they both support the concerns that we've been expressing all along. Ms. Sanderson has faced some difficult challenges. She's overcome many of them. None of us are denying that. But, and this is why the Oregon matter came into this. Her behavior in that case follows a pattern of the behavior that we saw in Washington back in from 2013 on when this was originally filed. This was before her supervised visitation was terminated. And it's also in the way she went about trying to renew her relationship with this child. She waited until Judge Warning had retired. She dropped right back in with a couple of 100 pages of a pleading to have the child come and stay with her immediately, despite any of our concerns about what happens with a child who went through the trauma of being kidnapped, the trauma of a highly contentious divorce between his parents, all of the allegations that his mother has made, including an ongoing allegation that Mr. Larson is not really the child's father because he may not have contributed DNA to this child. That was never determined in the court. That may or may not be the case. What is the case is that Mr. Larson is this child's father, and Ms. Sanderson can't let go of that. Her family can't let go of that. The guardian ad litem noted that in her report. We are very concerned about what happened in the Oregon case, and the guardian ad litem noted this in her report when things weren't going Ms. Sanderson's way. Once again, things weren't going her way. It was looking like the court was going to return this child to the mother, and after offering to help a family friend with a child that was unplanned, that was the result of an assault, Ms. Sanderson decided that she was going to, and the the documents, the healthcare documents support this. Ms. Sanderson asked the healthcare provider to make a request to notify CPS, have them notify CPS about a bruise on the child that she was suspicious of. This was nearing the end of that case in Oregon. CPS found no issues of concern, but she attempted to involve CPS against this mother when things weren't going her way. And coming to the end of it, when it was clear that the court was going to return this child to his mother, she reached out to the father, the biological father of this child, who went to prison for assaulting mom, and supported him in filing a motion to take custody of the child. Dr. Mayhar's concern, the guardian ad litem's concern, everybody's concern here is that no matter how much work Ms. Sanderson has done, and we acknowledge that, under stress, she reverts to these old patterns of behavior. In the guardian ad litem's report, it's pretty clear that the child's counselor, Mackenzie Taylor, has recognized that the child still fears being kidnapped by his mother. He has reverted to some pretty clear anxiety behaviors since this all started up again. He's said that he's willing to talk to his mom, but that is down to my client's support of this child and what's best for the child. Frankly, he'd rather have nothing to do with Miss Sanderson ever again, and I'm sure the feeling is mutual, but he's concerned for the child. And if this is something that the child wants, and that it can be pursued in an extremely careful, extremely slow manner, guided by what the child is prepared to deal with, he's willing to support that. This business about filing an appeal, I mean, is that a threat? This is of a piece with the behavior that she has displayed in the past. And that is where our major concern lies, is that regardless of what she says, regardless of her good intentions, which I'm sure she means, push comes to shove, when things get difficult, she reverts to trying to get around court orders. She is very likely to say and do things that are not good for this child, particularly when the child is already anxious. So, as I said, my client would just assume that there be no visitation. However, if the child expresses and continues to express an interest to have some sort of connection with his mother, he will support that. But we would ask that if the court decides that that is appropriate for this child, that it be, as the guardian ad litem was suggesting, that it be a PhD level reunification therapy. There's strict supervision of any contact with the child, with clear rules, a clear understanding of what's going to happen if those rules are not followed. And most importantly, that it will be entirely up to the child, with the help of his counselor, with the help of his parents, his father and his stepmother, who has acted as his mother throughout. If he wants to go, Mr. Larson will support that. If he doesn't want to go, he should not have to have contact with his mother until he decides he's ready to start again, if at all. That is where we would like to leave this, I believe, with the court. Unless Ms. Turnbull has something additional to add here. I think it's all there in her report.
Thank you, Ms. L. Ms. Winkles, for bottom.
Yes, Your Honor. A few things. I'm a bit confused at how this has been spun. Firstly, just to kind of knock them out each individually. The Oregon case, there was a directed verdict that the child was going to go back to his biological mother, which he hadn't seen in 3 years. Biological mother, during that case, admitted she was an alcoholic, and she essentially left the kid with my client. Nowhere in that case did any medical issues or any issues at all arise. In fact, the court said at, I believe, 536 of their, and I planned on putting the transcripts in. It's just, this was a 5-day trial, so getting them in a short amount of time has been quite difficult. But the court said that he considered my client essentially mom and biomom mom, and that my client had done an excellent job, but that the law was very clear. Biomom had gotten herself together, kid was going to go back. The issue then came when my client attempted to take the child to the doctor, and biomom had withdrawn all of her consent for this little boy to go to the doctor. It's been alleged that this little boy is somewhere on the spectrum and takes medication essentially given because of that sort of diagnosis. And my client put those medical records into this case as well, so that Your Honor would see them. So we have that, which doesn't show my client has done anything wrong. When I mentioned the appeal, it was as much for, if not more for, Ms. Dow's client than my client. My client's trying this out, but Ms. Dow's client, Mr. here, has violated the court order repeatedly. While he's coming in and say he'll respect that, he will push to have whatever the child wants. This has not been the case. He admitted in to the GAL, which you'll see in the report, that my clients called him for visitation. You'll see Judge Hahn's order that my client was entitled to a certain amount of visitation. She never got this. This is not a woman that has sat idly by for the last 3 years waiting for Judge Warning to retire. This is a woman who every time it's time for her visitation, she calls. Dad refuses to answer. We asked Dad in the last hearing why he hadn't given any visitation, and his reason was that he didn't believe it was appropriate for the child. Essentially putting his own opinion in instead of the court's. The court said she gets this visitation. Dad said, no, I'm not giving it to her. Yet Dad has not been held accountable for this at all. The reason that I mentioned the appeal is as much for Dad, if not more, than my client. The fact is that child has repeatedly stated to his counselor that he'd like to see mom. He stated that. This is not a kid who's on the fence. This is a kid who said he would like to meet her. This is also a child that repeatedly said the word kidnapped. Now, if you'll remember, the age of the child at the time this happened was very, very young. The likelihood of remembering that scenario is pretty small, which means it came from somewhere. The idea of Dad having any sort of power here and control over when child has visitation means that we're in the same place we are right now. There will be none. Dad, there's a court order. Dad is like, nope. Then what is going to happen? Child has all these recollections of something when he's very young, which is pretty much impossible. These recollections came from Dad. Dad is very clear. He doesn't want child to have any sort of relationship with my client. If we were allowing it to go based on that, my client would just have no relationship. Dad needs to not be in control of this. My client agrees. Master's degree would be easier. PhD is hard to come by. I think I only know of Dr. Poppleton, who is out about 6 months. Master's might be appropriate in this case, but reunification by counselor led, so that my client could essentially meet this child. 2 hours, Ms. Turnbull agreed. Also, Dr. Maharg agreed. And I think that's really important. We keep saying Dr. Maharg said this and that. It's not true. In fact, Dr. Maharg said, yes, she's going to have some stressors. Yes, she might revert occasionally back to some old behavior. But the fact is that it's more important for this child to have a bond with his mother and to have reunification with his mother than it is to worry about what DeVito might do. And that's in both of his reports. Every person in this case, minus Mr., has said that my client needs to start moving forward to having these visits. Again, how much does she have to pay of her life, of her, her relationship with her son to fix something where she had a mental health breakdown? This is a woman that clearly had a breakdown, who did and chose actions, a woman without a criminal record that did things completely opposite from how she'd ever done them in the past. This is a woman who had a breakdown, who fled, who did all kinds of things, and then immediately started working on herself to get better once she was over that initial hump. She is not perfect. She acknowledges that, but she's ready to do what the court wants her to do. If that means not stating anything about certain category of information, great. But the idea that this medical issues and all these issues are going to come up when it's reunification counseling and there's going to be somebody there, I think we're getting ahead of ourselves. She's not going to have any ability to change the child's medication. She's not going to have any ability to flee with them. She's going to be in a setting that's controlled with a psychologist watching her every action and assisting her and the child into forming a bond. That's what we're asking for here. So we'd ask that Your Honor allow my client to start to reunify with this child. We'd ask that it be master level, considering Dr. Poppleton is so far out and he's the only one that we know of. I believe Allison Long is a master level and she's doing that. But in any event, this child wants it. It's clear from what he stated to the GAL. It's clear from what he stated to his own counselor. And I think we need to honor that and remove Dad. Dad really has no part of that bond at this point. That bond is child's mental health, keeping that safe, and my client's mental health. Thank you.
Thanks. Starting with Jack, that's kind of the focus here, is best interest of Jack. Sounds like he's a great kid. It sounds like he's doing well in school. He's done great in his youth group. He's active in sports and athletics and team sports. It sounds like he's had a great stability with living with Mr. Larson, with his dad. There are some things that he has, some anxieties, the compulsive hand washing. Sometimes that comes up when he's triggered. It's been a long time since he's seen his mother. He also indicated that on a scale of 0 to 100, he said 77%, which I thought was an interesting figure that he threw out there. And that doesn't strike me as unusual. I think for most children, there's a desire to know their parents, for good, for better or for worse. There's just that I see it with people that have been adopted. A lot of times they'll have that need, just this strong innate desire to know their parent. So I note that. I note that the therapist of Jack is worried about his emotional safety. He's done a lot of work and he's been able to, as she said, retrain his brain. I think Ms. Turnbull may have used that phrase, to retrain. He's been really pretty stable for the past 2 years, which is fantastic. And she indicates that, any type of reunification counseling would be disruptive. That doesn't surprise me either. And that may increase some of his obsessive compulsive behaviors and maybe some increased anxiety. However, the counselor did note that there's some pretty strong protective factors in the home of Mr. Larson, of his dad, that there's safety, there's stability there, and Jack seems to have developed into a child who has a lot of resiliency. Dr. Maherg's comments, I think, are interesting and noteworthy. He's had professional contact with Ms. Sanderson, and while he's been unable to do a full, really in-depth type of workup, he has some concerns that Ms. Sanderson can appear very, very put together, very professional, very persuasive, and yet there's still these underlying issues that manifest themselves at times. So he feels that it's a drastic step to prevent a child and their parent from being with each other or having a relationship. So he suggests a very slow reunification period, and that there be adequate and abundant support for Jack, and that there be very, very, very close supervision and under controlled circumstances, and that would allow for a quick and swift intervention if needed to protect Jack. And he also said that he's concerned about any comments that may be conveyed to Jack that would undermine this young man's stability and sense of well-being by indicating that Mr. Larson isn't his real dad, which is, I think, to a lot of segments of the population very, very offensive, because a person adopts a child. They're quote unquote not their real father, not their real mother, but in fact, they are their real father and their real mother. And so that is a point well taken. And it's been a strong and pervasive sentiment within one side of the family. And I'll just make perfectly clear, there's a very strict order that no person, no parties are allowed to make any mention about parentage of Jack to Jack, and they are to control third parties. They are to control third parties from making any comment and prevent any comment to Jack, or even Jack overhearing such comments about his parentage. Dr. Maherg also talks about, and I don't know if this is his language or Ms. Turnbull's language, of sowing drama and trauma into the lives of those around her. Dr. Maherg mentions that, I think, in part to preserve and protect Jack, is that he wants to prevent emotional turmoil and drama and trauma that in the past he has seen has been present in the lives of those that surround Ms. Sanderson. He indicated that there have been some improvements in her mental health, but Ms. Turnbull has some concerns that may not be evident in her behavior as manifested in Max's case or Reese's case, the Lassard case in Oregon. So my sense here is that a child needs his mother, needs his father, and this is not a case taken in isolation or out of context. There's context to this case. There's history and there's water under the bridge. So I think that reunification is appropriate, but there's some strict conditions on how this is going to play out. So I think a PhD level reunification counselor is absolutely critical. There are some nuances that are here that need to be seen, and a PhD level person is going to be in a better position to spot maybe some telltale signs that may be worrisome that would escape the view of a master's level. That PhD level will need to be chosen. Both parties can chime in if you can agree on who that PhD level reunification counselor is. You can let the court know of that. If you don't agree, then you can each present a candidate to serve in that capacity, and then the court will make a decision who that PhD reunification counselor will be. During the period leading up to and including the reunification, unless guided otherwise by the PhD level reunification counselor, Ms. Sanderson will continue in her counseling with her mental health therapist. Jack will continue with his counseling with his mental health counselor. Once the PhD counselor has been selected, that PhD counselor will submit a report to the court and to the parties on how to proceed with reunification, a detailed plan. And that will be supplied to all the parties. That will be reviewed by the court with the assistance of the parties in court. And I think it goes without saying that there will be, at least initially, and may continue, I don't know, a high degree of supervision. And the court will need to, and also the reunification counselor and the parties will need to determine the means and the methods of quick intervention. That if something is amiss or there's a red flag or there's a misstep, there'll need to be quick intervention and mechanisms to allow for that to occur. In that way, I think that if we proceed in that fashion, one, the safety and stability of Jack is preserved to the degree that it's possible, recognizing the need for a mother and a child to build a relationship to the degree that it can be built, and hopefully it can flourish. And that also addresses Mr. Larson's concerns about past history of Ms. Sanderson, and it also addresses Dr. Maherg's concerns and also Ms. Taylor's concerns, the counselor. So that's kind of the overview and the direction that I'd like to see this case take. So any questions or points of clarification from any party?
Yes, Your Honor. How long do we, can we put a deadline on selecting somebody? I just don't want it to go out too far.
Sure. My sense is, as you've indicated, Ms. Winkles, there's not a lot of PhD level reunification counselors in Southwest Washington. I think, a reasonable time period would be 60 days. Does anybody have any concerns with a 60-day period? I think that allows for some identification of potential counselors, checking sources, asking around, double checking. So 60 days.
Okay, sounds good.
I think I can work with that, Your Honor.
Okay. All right. Any other points of clarification or questions?
No, Your Honor.
Your Honor, I'd like to just clarify one thing.
Sure.
You were saying, I believe, and please correct me if I have this wrong, that until the therapist has had a chance to talk to the child, talk to the parents, and can generate and present to the court, either through the guardian ad litem or through the parties, a clear-cut plan for reunification, the situation will remain status quo as far as Jack's contact with his mother.
Accurate.
All right, thank you.
That's correct.
Your Honor, would you like me to remain on this case or would you like to discharge me?
That sounds so harsh, discharge. So trying to think ahead, the PhD reunification counselor will submit a report and it'll lay out the contours of the process of reunification. That reunification process, we will have, I'm sure, updates from the reunification counselor. We'll have updates from visit supervisors. We'll have updates from counselors. So I'll be able to hear Jack's voice via his counselor. I'll be able to hear Jack's voice through visit supervisors. I'll be able to hear Jack's voice through the PhD level reunification counselor. There's also, so I'm leaning towards yes, towards discharge with a potential of being reappointed if need be.
Okay.
So if any party concerned with that, if that approach, if
We're fine with that, Your Honor.
Ms. Winkles?
Yes, I'm fine with that, Your Honor.
Okay. So Ms. Turnbull, do you generally submit just some paperwork that says you're hereby discharged, or is that something that's just done on the record? Or what is your?
I generally just do that on the record.
Okay. All right. All right. You are hereby
That's
discharged
acceptable.
on the record. Okay.
Thank you.
All right. Very good. All right. So with that, if there's no other issues, that'll conclude today's hearing. And thanks to the parties for your input.
Thank you, Your Honor.
Thank you, Your Honor.